Hello, welcome to Trusts and Estates. This is a course about the transfer of property at death, which is a subject of huge financial and also emotional importance to almost everybody. This first slide gives you a rough breakdown of the course. Half of the course is about wills, and I'm sure you know what that means, and intestacy. Intestacy is, of course, the state of not having a will, not having a testament. For people who do not leave instructions for who's going to get their property after death, the state has a default plan by which the property goes to the nearest relatives, and they're called the heirs in intestacy. Now, for hundreds and hundreds of years, wills and intestacy were the only way to transfer property at death. In the last century, however, new mechanisms have been devised for achieving this end, each with its own advantages. And the most notable of these is the trust. Now we're going to get to trusts in the second half of the course. You'll see that's the large green slice of the pie. But to avoid confusion, I'm going to give a mini explanation here. When a person puts property in trust, it means that he transfers the property to a trustee to manage and use for a given purpose. Let me give as an example charitable trusts. The grantor, that's the official name, gives money for the purpose of, say, a school for the blind. The property is managed by the trustee, or probably a board of trustees in a case like this, and the trustees are the legal owners of the property in the sense that they have the power to invest it, spend it, borrow against it, etc. But they're very restricted in what they can do with the property. They're not owners in the usual sense. They can only use the property for educating blind children. You could say that the charity is the beneficiary of the trust, or maybe the blind students are the beneficiary of the trust. In any case, the trustees can only use the property for the beneficiaries, or in this case, a charitable purpose. Now, I'm tying myself up in knots a bit here because I chose a charity as an example where the beneficiary isn't so clear, but I'm using it because it's an example with which you're probably familiar. You may also know about trust funds. Again, here the grantor, a parent or ancestor, transfer the property to trustees who manage it and distribute it to the beneficiaries, usually as income. And trust funds can be set up to run for generations. There are three parties to this arrangement. There's the grantor, the trustee, and the beneficiaries. Oh, and the property itself. I've never found any visual illustration that really made this clear, but on the next slide I'll give you one that I got off the web, and you'll see why illustrations don't really help. Now, trusts have been around forever in England, especially charitable trusts. But the concept has been expanded for all sorts of uses in the last century, including, of course, business arrangements like retirement funds. And in every kind of trust, the key element is the separation between the trustee who manages the property and the beneficiaries who are the equitable owners of the property. And of course, trusts have been used as a mechanism to transfer property at death. Now, besides the trust, you'll see in the lower right-hand slice of the pie other transfers. These are other means of transferring property at death. For example, life insurance. You may not have thought of that as a transfer at death, but it is. Joint tenancies with right of survivorship. You remember that from property law. So there are other means by which property is transferred at death. And then we're going to end the course with protections for the surviving spouse. Because in American law, you can do almost anything you want with your property. The one thing you cannot do is leave your spouse impoverished and a ward of the state. Well, here you see why illustrations aren't much help. This merely puts into pictures what I said on the last slide. In a trust, the grantor gives property to the trustee who has power to manage it, but can only use it for the purpose that the grantor specified in the trust document. That is, to use it in a trust and estate situation, to use it for the beneficiaries, often to pay out the income to the beneficiaries. Here we have an overview of today's course. I'm not sure I should read out each of these slides. After all, slides are visual. They provide the information in a visual way. But just in general, we're beginning with the probate courts and the probate process. The probate court is the one that supervises the actual transfer of assets from the decedent's estate to the beneficiaries. Then we're going to talk about intestacy, the state default rules for the distribution of assets if the decedent did not leave a will. This could be fairly complicated depending on how distant the relatives are, and there are special rules for half-siblings and children born outside of a marriage and so on. And then we're going to turn to initial construction issues. So construction is usually how to interpret a will if the donor, the testator, hadn't foreseen certain developments when he wrote the will, but construction also comes up in case of intestacy. So you see the list here. We're going to talk about advancement, Slayer statutes, and disclaimer. Okay, again, not much to say here really. The probate court is the first body to rule on the validity of a will. It serves as a clearinghouse for creditors who have claims against the estate. It validates the transfer of title to property, and that's particularly important for real property. The person who inherits the house needs to have title to the house, and the probate court is the one that transfers title to that heir. So probate is where all of the cases in this book began. Eventually they might be kicked up to appellate courts, but every will contest, every distribution of assets begins in the probate court. I mentioned earlier that in the not so distant past, the only way to transfer property was via will or intestacy. And our laws about wills and intestacy go back all the way to the Middle Ages. The rules originated at a time when wills were written on the deathbed, or rather they were dictated by the dying person, because many people couldn't write. They were often dictated to a priest, and the testator, that is the person who was making the will, was sick and vulnerable. And that raised all kinds of questions and demanded all kinds of safeguards. The questions were, was this will really dictated by the deceased? Or was it perhaps a forgery? Was the dying person coerced or perhaps defrauded, maybe by the priest who threatened eternal damnation if the dying man didn't give his money to the church? Was the dying person of sound mind? Not an unreasonable question of someone who's dying. Now, our very, very strict rules about authenticating a will come from this environment. There still is, an obsession with detail. There must be two witnesses. They must have seen the testator sign. They must have seen each other sign. They must not be beneficiaries of the will, etc., etc. And then the will had to be found valid in a probate court. This system trusted no one. Here I introduce non-probate property, property that is transferred at death outside of the probate courts. We are now used to, we're completely comfortable with, entrusting all of our assets to corporations. That is, our cash, stocks, pensions, and so on. And we're comfortable with making enormous transfers with a click of a mouse, with a tap on a phone, for heaven's sake. Not to mention the fact that our assets take the form of electronic records. So a millionaire is someone with certain bits of computer code on some company's computer somewhere, not land, which used to be the main form of assets. What guarantees the integrity of these transactions? Well, it's mainly our trust in the corporation. I trust that if someone hacks into my account or steals my username, that Bank of America will do the right thing and will make it up to me. And if I trust the Bank of America that far, then I trust it to transfer money to my designated beneficiary after my death. My account at the bank has a transfer on death provision so that at my death, my beneficiary will show up at the bank with a death certificate and all of my savings will be transferred to that person. No probate court will even know about this arrangement. That's why we call it a non-probate transfer. The whole thing happens outside of probate. It's not subject to the rules of probate. There is a whole menu of non-probate options for transferring assets without court supervision. Trusts is the big one. Trusts were originally created for a different purpose. They're now used also to transfer assets outside of probate, and we'll see later how that works. If you're very clever, you can use workarounds like this to avoid probate altogether. Well, except perhaps for the house. Most people still need probate to transfer title to the house, although there are ways to avoid that, like joint tenancy with right of survivorship, although that's not perfect. So again, this introduces you to the idea of non-probate property. It's any property that's transferred outside of the probate system. The difference is, well, it might sound like it's just a matter of nomenclature, but it is vastly important in the sense that probate property is subject to the rules of probate, the first half of this course. Non-probate property passes basically through the rules of contract. Again, this difference between probate property and non-probate property. It's not really a distinction between the kind of assets. So money in a bank account can be either probate or non-probate, depending on how it's transferred at death. If I don't make special arrangements with the bank to have it transferred to my intended beneficiary, then that bank account money will pass through probate. If I do use one of these clever tricks, I can avoid probate and the property becomes non-probate property. So among the clever ways of transferring property at death outside of probate, and again, lawyers have explored these and expanded them and used them in clever ways. Joint tenancies with right of survivorship, life insurance, bank accounts with payable on death provisions, stocks with transfer on death provisions, and interest in a trust. Those are some of the obvious non-probate assets. Again, the asset isn't different from the probate assets. It's the way that they will be transferred at death. Here is some vocabulary that you have to know. I'm not going to read it all out. You can read it for yourself. You can print it on a handy card to carry in your wallet. We'll talk about the personal representative or executor or administrator of the estate. There are small technical differences between those, but I'm going to use the words interchangeably. The probate court may have different names depending on the state. There's the surrogates court, the orphans court, chancery court. Heirs or next of kin are the people who would take in intestacy. So we're talking about intestacy today. The rules of intestacy define who the next of kin are, who the heirs are. Informal probate and formal probate, read about that yourself. The last slide mentioned the personal representative or administrator. This is the person who shepherds the will and the property that's passing under intestacy through the probate system. That person's job is to collect the assets, pay off creditors, and distribute the estate to the beneficiaries. This slide is a picture, sort of a letter testamentary. That is a letter issued by the, in this case, surrogates court, but that's the same as the probate court, to the administrator, authorizing him or her to show the letter to the bank so that the bank will hand over the assets to him or her. We will not cover the estate tax. This used to be a big part of the course because the tax used to kick in for estates over $600,000, which is about the price of a house in New Jersey. Now, however, the first $5 million or so is exempt from tax. The exemption was raised rapidly until 2013. Now it continues to rise by a small amount each year, a small amount measured in the hundreds of thousands of dollars, and 5 million plus per person amounts to 10 million plus per couple, which means the middle class is no longer affected by the tax, and we have so much else to cover in the course. Tax is now an issue for 0.2% of the population. You'll be lucky when you get clients with those kinds of assets. As we're going to see, the law of wills has been inflexible to the point of idiocy. So if there's even one tiny slip, if one of the witnesses steps out of the room to get a tissue or something like that at the wrong moment, then the whole will fails. Now that's changing, partly under the influence of the UPC. Another force for change is attorney liability to third-party beneficiaries. So when someone goes to a lawyer to get a will, he's doing that for the benefit, of course, of his children and friends and charities and whomever is going to benefit under the will. But the contract runs from the lawyer to the will executor, not to those intended beneficiaries. And in the past, if the lawyer messed up, the intended beneficiary who didn't get the bequest that the testator wanted him to have didn't have a cause of action against the lawyer, which was a nice insulation for the lawyer, because if a mistake appeared before the testator's death, it was easy to fix. If it appeared after the testator's death, well, there was no one who had a cause of action against the lawyer. That is changing. Now in more modern jurisdictions, the intended beneficiary does have a cause of action against the lawyer. No wonder lawyers are suddenly interested in more flexibility in the interpretation of wills. That would mean that minor errors, the lawyer's minor errors, would not necessarily lead the will to fail or would lead the bequest to go to the wrong person. Maybe now lawyers will advocate more for remedial measures. The intestate share of a surviving spouse has changed radically over the years as the concept of marriage has changed. In traditional common law, that is up until the 19th century, a surviving spouse inherited nothing in fee simple. That is, nothing that she could sell. What she got was a maintenance called dower during the rest of her life. She had a right to support from her husband until her death. So in the 19th century, the law began to think of the widow as an heir, as someone who would inherit from her spouse, and to assimilate her to the other heirs, the children. And the intestacy statutes were a best guess as to what the decedent would have done had he had the elementary sense to draft a will. So the average person wants to provide for his or her spouse and children, and the intestacy rules regarding the spousal share is our best guess as to what the decedent would want to leave the spouse. The old rule, the first guess, was that if there were children, their surviving spouse gets at least a half share of the decedent's estate, the rest going to the children. The more progressive approach is to be even more generous to the spouse in the belief that's backed up by empirical evidence that this is what most decedents want. Instead of giving half to the surviving spouse, modern statutes give everything to the spouse unless either the decedent or the spouse had children from another relationship. Here is the UPC's take on, or best guess at, what people would want to leave a surviving spouse. Now, I mentioned that the Uniform Probate Code and also the Uniform Trust Code are drafted by reporters who are usually academics, and they take a very progressive approach. And that means, as I mentioned earlier, that they're more forgiving, or the UPC is more forgiving about mistakes in the execution of a will, more willing to admit extrinsic evidence to discern the testator's real intent. And it also means that the UPC is more tailored. So in intestacy, for instance, the UPC doesn't have one blanket rule for who takes the decedent's estate. it has different rules for distributing the estate depending on whether the decedent or his spouse had children from other relationships, for instance. And since it tries to account for all kinds of different scenarios, the UPC rules are longer and more complicated than the older codes were. That's to introduce the UPC's rules for the share of the intestate share of the surviving spouse. Simple enough if all of the children in the picture are children of this relationship. In that case, the surviving spouse gets everything. But if either the decedent or the spouse had children from another relationship, then the UPC starts designing quite complicated calculations for what the surviving spouse should have. And the calculations are different when it's the decedent who had a child from another relationship or the surviving spouse who had a child from another relationship. So for example, subsection 3 here, if all of the decedent's children are also the spouse's children, but the spouse has another child, then the spouse gets $225,000 off the top and a half of the rest. You'll be doing some exercises on this, and we'll be talking about the rationale behind the UPC's spousal share in class.